The government today took the Waitangi Tribunal to court over its unprecedented move to subpoena the Children's Minister before she repeals a section of the Oranga Tamariki Act.
It's the first time a minister has been required to give evidence or face a criminal offence. Political reporter Amelia Wade was in court.
Right across the road from the Beehive, two arms of government are in a constitutional clash.
This is an unorthodox, to use the words of the claimants before the tribunal, and actually unprecedented event.
Till 11 days ago, we had a nice, workable state of constitutional balance and mutual restrict and restraint. That state of equilibrium has been shattered by the conduct of this minister.
It's Parliament versus the Waitangi Tribunal over the latter's decision to summons the Children's Minister because she refused to voluntarily appear or respond to questions. She lawyered up.
So the basis of the challenge is the coercive aspect of the summons, which obviously has the corollary of being an offence to not meet it.
The tribunal's hearing an urgent claim about the coalition's plan to repeal what's known as Section 7AA of the Oranga Tamariki Act. That clause requires a consideration of Tamariki's whakapapa and mana when deciding where to place them.
My worry is that without that commitment in law, that we're really up to the leadership in the organisation. That's what we're going to be left with.
ACT campaigned on repealing it and got it inked into its coalition deal because of concerns it was leading to reverse uplifts where Māori Tamariki were being removed from Pākehā.
Very simply, we want to prioritise the health of a child, of our most vulnerable children.
The Crown says it was a promise the coalition was built on and a decision made by Cabinet.
The tribunal mistakenly thinks the minister is the moving mind, they say. They're mistaken by that.
But Cabinet papers show officials don't support the repeal, and it was argued that's why the minister needed to explain her thinking.
That's what the tribunal is grappling with. How can you have a policy that the minister is putting up to Cabinet in her final Cabinet paper that is so disconnected from the policy analysis of the officials undertaken in a free and frank sense?
Also at play is the notion of comity. That's the mutual respect and restraint between two arms of government, the courts and Parliament. Each side argued the other trampled on it.
Comity is a two-way thing.
Justice Andrew Isaac will make his decision on Wednesday.
Well, OK, Amelia, ACT got themselves in hot water on this last week. Any update there?
Yes, this beef extends beyond the walls of the courtroom. So when the Children's Minister was first summoned before the tribunal, ACT issued a press release blasting the decision, saying they messed with the wrong woman on the wrong issue at the wrong time. And New Zealand First Minister Shane Jones was also highly critical of the decision. But those comments earned them a public rebuke from the Prime Minister on Friday, who said that those comments were ill-considered. But that appeared to have surprised David Seymour, who said he thought that concerns were best raised behind closed doors. Now, when the Prime Minister was asked today about the conversations that he'd had with the ministers, he said that the court hearing today meant that he wasn't able to comment because it was before the courts. However, that same logic doesn't seem to have applied to David Seymour, who says no, he didn't get a telling off, and he does very much stand by his attacks on the tribunal.
OK, Amelia, thank you.